What is the law? It's a simple question, a child's question, and yet it's the foundation of civilization. The French philosopher Frédéric Bastiat answered it in 1850. He wrote, "The law is the collective organization of the individual right to lawful defense." Collective organization, individual right, lawful defense. The law exists to protect all individuals equally. It does not play favorites. It does not look at your birth. It does not look at your name. It looks only at your right to exist in peace. On March the 20th, 2026, a date I fear will go down in history, a man named Mahalingam Balaji stood before the Supreme Court of India. He appeared in person, and he stood before Justice B.V. Nagaratna and Justice Ujjal Bhayan. He didn't ask for wealth. He didn't ask for privilege. He asked for a lawful defense. He filed a petition seeking recognition of a very specific, very real phenomenon, anti-Brahmin hate speech, which he termed Brahmophobia. And he asked that it be recognized as a punishable form of caste-based discrimination. He asked the court to look at the reality of his people. He had documented their poverty. He spoke of a priest in Tamil Nadu, a man who could not feed his own mother. She died of starvation. He spoke of Brahmins in Bihar, living in bamboo huts in the 21st century. He brought data, hard, unforgiving data. From Karnataka in the 1970s, he showed that Brahmins had the lowest per capita income of all communities, just 537 rupees, lower than scheduled castes at 680, lower than Muslims, and lower than Christians at 1,562. He submitted, we are easily identifiable. The traditional hairstyle, the religious markings, the attire. We wear our identity on our skin. This makes us easy targets. Directed hate finds us without effort. Balaji quoted Professor Jeremy Waldron. The costs of hate speech are not spread evenly across the community. Waldron tells us we must speak to those depicted in this hateful way. We must speak to them before we conclude that tolerating such speech builds character. Balaji even reminded the court of its own words. The Pravasi Bhalai Sangathan case. The Supreme Court itself had said effective regulation of hate speeches at all levels is required. He asked for a Truth and Justice Commission to investigate the 1948 Maharashtra Brahmin genocide, to investigate the 1990 Kashmiri Pandits genocide. He asked for these truths to be in our textbooks, and he asked for action against coordinated campaigns inciting caste hatred. He asked for the law, just the law. How did the Supreme Court of India, the highest court in the land, respond? Did they invoke justice? Did they offer the shield of the Constitution? No. They offered a lecture. Justice Nagaratna said this: "We don't want hate speech against any community. It depends on education, intellectual development, tolerance, and patience. Once everyone follows fraternity, automatically there will be no hate speech." Fraternity. Once everyone follows fraternity, automatically there will be no hate speech. I'm a scholar. I study words. I study their meanings. And I study how they are used to hide the truth. This is not jurisprudence. This is gaslighting. Imagine telling a victim of documented, systemic hate speech that the solution is for society to become more fraternal. It deflects from the legal obligation to act now. It places the burden back on the victims as community. They are somehow expected to inspire their persecutors to be kinder. They're offered an aspirational ideal as a substitute for a legal remedy. Bastiat warned us of this exact moment. He called it false philanthropy. He wrote that fraternity cannot be legally enforced without liberty being legally destroyed, and thus justice being legally trampled underfoot. The court used the word fraternity to trample justice underfoot. They used a beautiful word to deny a basic right. They told a bleeding man to wait for the world to become a brotherhood. Is this the function of a constitutional court, to act as a moral philosopher while denying legal protection? Bastiat said, "The nature of law is to maintain justice. Law and justice are one and the same thing." A court that refuses to even hear a claim of systemic hate speech fails this test. It separates law from justice. It leaves the citizen defenseless. Bastiat also observed that when law and morality contradict each other, the citizen has the cruel alternative of either losing his moral sense or losing his respect for the law. He wrote this in 1850. 175 years later, a Brahmin scholar walked out of India's highest court carrying precisely this contradiction, told by a robed authority to look inward for fraternity, while the court itself declined to look outward at injustice. The moral sense and the legal trust both wounded in a single afternoon. But the gaslighting did not stop at fraternity. Justice Nagaratna asked another question. She said, "Why should a particular community come up and say, 'Protect my community against hate speech'? Rather, we should say, 'No one should indulge in hate speech.'" It sounds so egalitarian, doesn't it? So universal. But let us examine the hypocrisy. Let us look at the double standard. India's courts routinely hear petitions from specific communities. They hear cases on atrocities against scheduled castes and scheduled tribes. They hear cases on minority protections. They do this daily. Do the justices ask those petitioners to universalize their pain? Do they say, "Why should your specific community ask for protection?" No, they do not. A Dalit petitioner is never told, "First prove that all castes suffer before we hear your case." A Muslim petitioner is never told, "Come back when you can represent every religion equally." A tribal community is never told, "Your forest rights must be reframed as everyone's forest rights before we will listen." These communities rightly bring community-specific petitions, and the court rightly hears them. That is precisely how targeted discrimination is supposed to be addressed, by name, by community, and with specificity. The standard shifts only when a Brahmin walks through the door. Suddenly the court discovers a principled objection to community-specific petitions. Suddenly, universalism is the only permissible framework. One can't help but notice the principle appears exactly when it is most convenient for dismissal. They recognize that specific targeting requires specific remedies. And yet, apparently, when a Brahmin stands before them, suddenly the rules change. Suddenly, the petitioner must speak for all of humanity before his own grievance can be heard. This is procedural gaslighting. It is a moving of the goalposts. Consider what's actually being said beneath the polite language. It is being said, "Your grievance is too narrow, too parochial. You must first prove that you speak for all humanity before we will hear you speak for yourself." This is a standard applied to no other community in this court. No other petitioner is held to this impossible threshold. And notice what this logic does, is it renders community-specific harm legally invisible. If a pattern of violence targets a specific identifiable group, and only that group, then demanding a universal remedy is not equity, it's erasure. It dissolves the specific wound into an abstraction which is so large that no one is responsible for treating it. In his writing, Bastiat tells us to see if the law takes from some persons what belongs to them and gives it to other persons to whom it does not belong. He actually calls this legal plunder. Here the plunder is not of property, it's of protection. Legal protection is being denied to one community while it is freely granted to others. And what does this do? Bastiat gave us the answer. In the first place, it erases from everyone's conscience the distinction between justice and injustice. When the law selectively protects, it corrupts the moral framework of the nation. It tells one group, "Your pain is not real. Your history is not valid. Your genocides do not count. The Supreme Court then told Mr. Balaji to raise his concerns before appropriate forums, not the judiciary. Where else does a citizen go when his fundamental rights are violated? The Supreme Court is the appropriate forum. Sending a fundamental rights petitioner elsewhere is not a redirection, it is a denial of justice. When Balaji pointed out that the judiciary itself was being targeted on social media by these same hate campaigns, the court brushed it off. They said they were not concerned about uninformed attacks on it. They missed the point entirely, or perhaps they chose to miss it. The attacks on the judiciary are part of the design. They are meant to delegitimize the very institutions that might offer Brahmins legal recourse. By dismissing this, the court deflected from the substantive threat to the rule of law itself. Mr. Balaji was effectively forced to withdraw his petition. He walked out of the Supreme Court, the highest court in the land, carrying the weight of the 1948 Maharashtra massacres, carrying the weight of the 1990 Kashmiri Pandit exodus, and carrying the weight of the starvation of a Tamil priest's starving mother. He carried it all back out into the street. The court would not hold it. Bastiat wrote that when you challenge the morality of these institutions, it is boldly said that you are a dangerous innovator, a utopian, a theorist, a subversive. The court's dismissiveness echoes this perfectly. They viewed the demand for equal protection as an annoyance, an interruption of their grand theories of fraternity. But what happens when the law defends the plunderers? Again, Bastiat warned us. Sometimes the law places the whole apparatus of judges, police, prisons, and gendarmes at the service of the plunderers and treats the victim, when he defends himself, as a criminal. It seems to me that we're approaching this precipice, a judiciary that is no longer facially neutral, a judiciary captured by identitarian biases. Again, Bastiat considered this and gave us three choices for society. 1, the few plunder the many. 2, everybody plunders everybody else. And 3, nobody plunders anybody. The court, in refusing to extend protections equally, has chosen the first. They have allowed the ideological plunder of a minority to continue unchecked. The safest way to make laws respected is to make them respectable. When law and morality contradict each other, the citizen faces a cruel choice. He must either lose his moral sense or lose his respect for the law. This is the historically evidenced destination of a judiciary blind to its own biases. When the blindfold slips, when the scales are tipped by woke ideologies, the institution itself loses its respectability. Balaji was not asking for revenge. His community was not asking for supremacy. They were asking only that the law be the law for everyone. Until that day, he will wait. He will document their history, he will remember their dead, and he will continue to hold a mirror to a court that tells him to seek fraternity while it denies him justice. I'm reminded of a letter which Jefferson wrote to John B. Colvin, in which he wrote, "The laws of necessity, of self-preservation, of saving our country when in danger, are of a higher obligation. To lose the country by scrupulous adherence to written law would be to lose the law itself." I rest my case, but I'm confident that Balaji's case will not rest here. Om.